10-minute call. You can find out more about that there in that chat window. I'll go over that in just a few minutes, but I do have a question that has come in. Sophie, and I know you covered this a bit, and of course, Kivanç, feel free to give your thoughts as well, but there seems to be, and I know that you covered this a bit, but if we could drill down, there seems to be some confusion surrounding the 20% screen. And in practice, do you expect it would serve as an effective safe harbor for transactions that fall below that 20% threshold?
That's a good question, and certainly one about which there is a lot of interest and debate. I think, you know, the guidelines could change, right? They're not final yet, so my comments just apply to how this is written right now. But I think in their current form, the draft guidelines really require a fact-specific competitive effects analysis, which is not a departure from the status quo. So I don't think the 20% screen would change that and create an absolute threshold for whether a transaction is subject to an investigation or whether it's quickly cleared. That said, the 20% screen would have implications. So if a transaction exceeds that screen, parties should probably be prepared to articulate early on why their merger does not raise concerns and doesn't require a lengthy investigation. And it could also kind of, practically speaking, I think there's a potential that it would create a higher burden for staff at FTC or DOJ to justify a quick close when a transaction does exceed that screen.
Excellent. Thank you so much. Kivanç, any thoughts on that before we move on?
Yeah, I touched on this brief. Hi, I touched on this briefly. I agree with Sophie. It remains to be seen.
Excellent. And time for, I think, just one more question that's coming in before we wrap up. And Kivanç, I know you did also touch on this. If we could talk a little bit more, how do the draft vertical merger guidelines compare to the existing guidelines in Europe?
Sure. Yeah, I haven't done a complete comparison, but actually my colleagues, Peter Davis, Kostis Hagizakos, and Bob Major, they've done it. They have an article that covers this topic in detail. So if you want a more in-depth analysis, look for that article. But let me highlight a few things. First, the safe harbor. We've been talking about the safe harbor. The safe harbor definition is different. So it's 20% in the draft US guidelines, but it's 30% in the EU non-horizontal merger guidelines. So given this lower market share threshold, the US guidelines may result in a wider set of mergers receiving attention. Another interesting note is that the draft US guidelines do not contain a statement that vertical mergers are less likely to generate competitive harm than horizontal mergers. The EU non-horizontal merger guidelines do have such language. And interestingly, the old US non-horizontal merger guidelines, they also had similar language. I'm not sure what this observation, if it has any practical implications, but it may be an indication of the increased focus on vertical mergers.